Okay, great. Thank you everyone for joining us today for our webinar. Today our topic is understanding the current California property tax rules, how it affects real property transfers and the inheritance. We all know Prop 13 California and Prop 19 affect property tax reassessments, property transfers, and inheritance. Unlike some states, the property tax is reassessed in California on each year basis. So Prop 13 is the reason property tax can only increase at a maximum of 2% a year. But we also know with Prop 19, it allows a full reassessment when a change of ownership occurs, either by death, gift, or sale, unless it falls into one of the exclusions. For today's English webinar, we're inviting attorney Michael Lee to join us to discuss about the current property tax laws and how it affects real property transfers and the inheritance. So first, Michael, do you want to introduce yourself?
Oh, welcome. Hey, audio good? I tried my new
Yes, we can hear you.
my new microphone. Oh, great. Well, welcome everyone to the webinar. I appreciate everyone joining us. This is our day webinar that is in English. So this is really suited to me because I speak English. So what we'll be talking about is California state, the local property tax rules, and we'll give you a little bit of a lay of the land here. And we'll see that this information will be fairly, 1,000-foot view, broad brush, because as we'll get into this a little bit further, this is massively complicated. And this is massively complicated for two reasons that make this a difficult area to sometimes give legal advice. And I shouldn't say difficult to give legal advice specifically. Specifically, it's perfectly fine and doable to give legal advice. But in this format, the broad webinar format, we're generally going to be giving you broad principles because, one, the law is very, very complicated on this. And two, this is an area that tends to be very, very fact specific. So if someone just says, well, my deed says this, what should I do? Well, that's not enough. I can't make a decision on that. What does your deed say? What does the deed before it say? How did you get this? What's the plan? What's the next deed going to look at? What does your property tax bill look like? Do you have the homeowner's exemption? There's all of these questions that need to be asked. Otherwise, it is very, very likely that one will get a wrong answer. So what we'll try to do is give broad ideas to give you the right direction so you understand the issue, and then one can go from there.
This fits exactly what I was going to announce. Our webinar has been prepared for information purpose only and does not constitute legal advice. So especially as Michael mentioned, for property tax, it's really a very complicated area of law. So if you have individual questions, please schedule a consultation with us. And this webinar, the information we provide is just for information only. Okay, without further ado.
Can I
Yes.
jump in just with the thing for this disclaimer? Please, under no circumstances, go execute a deed based on what we see here. And please, even if you after this you say, okay, that firms up my own research. I went and I checked the county assessor's website. I checked this. I'm going to go do a deed myself. Please get thorough advice before ever recording a deed, because a deed essentially is the transaction, and it is almost impossible to undo it without significant consequences. So this is the classic area of get informed, understand, do research, but certainly not something to say, oh, okay, I'll just off the cuff take some action, because this action is very, very serious when we deal with deeds.
Sounds good. Yes. So, Michael, to begin with our conversation, since we're discussing property tax rules, I think the threshold question is, does property tax only apply to real properties? And if so, can you tell us what is considered a real property?
Well, essentially, for our purposes, what we are dealing with is the California Revenue and Tax Code, the California property tax rules for real property. So we're thinking the land, so our homes, our rental homes, unimproved lots. We're thinking the parcel, what's described in that legal description where it will say, bearing northwesterly along, the Hanson borderline, that sort of thing. We're dealing with that. We're also dealing with things that are all within the land. So if there's mines, minerals, oil, we've encountered this sometimes. We have some clients in Ventura, oddly enough, their land has oil rights, and it's actually valuable. Actually, if you drive down, the what is it, the 101 freeway, and you hit that part after King City, there's oil. Actually, Upton Sinclair's novel, Oil, it's not about Texas, it's about California. So mineral rights, that's involved here. And then also improvements, things like the buildings, structures, all of that, unless they're exempt, under, certain situations. There's an exemption for date palms, for certain things. But basically, the parcel itself and the structures. And you'll see that on your property tax bill, where there'll be the land part and then the structure part. There is a narrow band of California real property tax in the commercial context for commercial equipment, but we're not going to talk anything about that. So like if I have a restaurant and I have all that stuff in there, there are occasions where I owe a property tax on that, but we're not talking about that at all. We're just talking about real property today.
So yeah, so if a business own, for example, personal properties, commercial properties, there's another tax can be applied. It's not this property tax we're talking about, right?
Exactly. So there is a real property tax, part of the revenue tax code, and there is a personal property tax for commercial property. For example, if I own a manufacturing business and I have all the equipment to manufacture the stuff, there is technically a tax there, but that's a very special situation. So that we're just going to set that aside. And when we're talking about property tax, we mean like the dirt and the house on it. That's what's going to be most common for, I think, everyone.
Great. So in California, if as a homeowner, anyone owns a house, we probably know our property tax is not reassessed every year. I mean, in a sense, because you won't just, suddenly receive a large property tax bill. Can you explain why in California we do not have this, this sudden large bill issue, and what is the law behind that?
Yes. So let's go on to our next slide and give the preview of what we've got here. So this goes back to the 1980s in California, and essentially a political movement in California that wanted to stabilize property taxation in California. And it's actually something that really this is done by the particular interest group, the Howard Jarvis Tax Center, and all of these people. A lot of it was actually from Southern California, though we feel it heavily in Northern California. And this movement in the 1980s and throughout was an effort to try to stabilize property taxation because California property values were rising rapidly, and it was pushing people out of their homes, because people bought the home and they say, okay, this mortgage, this property tax bill, this HOA, whatever, utilities, yeah, that's in my budget. And then if we didn't restrict the increase of property taxes, they could get very, very high. Actually, the center of this was Thousand Oaks, California, but actually it's more applicable here, that the properties valued, the values went up quickly. So what happened as a result of this is there was a proposition, when we vote, every few years, and we have those propositions, there was a big one, Proposition 13. And this is where we created the general rule that we have these established base year values, and you have your established base year value. And once you're the title holder, the rate of increase is restricted on assessments of no greater than 2% each year, and a limit on property taxes of 1% of the assessed value, plus, and this is a key thing, plus voter approved taxes. So this is something where people say, well, wait a minute, I'm in XYZ county, XYZ city, I pay more than 1%. Somebody voted for that. That's where you get that. The same way if you say, well, wait a minute, I also have this other thing tacked on because I'm in Sacramento or I'm XYZ place, the Melrose. The Melrose is something else. You're paying for that park or that school assessment or something like that. So this is just the pure general rule of the property tax, is that it shouldn't go up more than 2% each year and have this limit of 1% of assessed value. So the effort of this was trying to essentially freeze the property tax calculation with minimal inflation adjustments. But what we're going to see is, okay, that's great. We froze the property tax system in the sense of that we only, once the value is set, that's how we tax. But the question then is when and how is the value set? And we had to create a system of when is there a trigger for the county to change the assessment? And this is where the problem comes in. In California, and we'll get to this our next slides, is the critical thing for California property taxation is change of ownership. And what happens here? This is I wouldn't say very unusual, but is somewhat unfamiliar sometimes from people for other states, because in a number of other states, they do not have Proposition 13. Again, this is state by state. This is a California state thing. Other states say, well, wait a minute, we don't have this. We, each year, the counties, they assess, the regions generally, and sometimes your property tax can significantly go up and up and up and up and up. And there are some limits how much per year they can increase it and things like that. But you are not as protected as California if you're in an area that became. We have one, Washington State. We had clients, they were on an island, and you had to take a ferry to the island. So values were pretty low because to get anywhere, you had to drive the car to the dock, wait for the ferry, drive the car to the ferry, pay for the ferry, get across the thing. Well, they built a bridge. As soon as the bridge was there, the whole ferry system was over, and you could just drive in and out. Property taxes went up, and it went up very, very quickly. So we don't have that. So what we have is this issue of change of ownership. And this goes back to our warning. So what does this mean? We have to be very, very careful when we touch that deed, because that can trigger a change of ownership.
So many people, many of our clients mention California is a high tax state, but actually when you analyze it, there are some taxes actually in California is very friendly to people. One is, as Michael just mentioned, is the property tax. So we do have Prop 13 to protect homeowner from reassessment of the value of the house each year. And then we also have, Michael just mentioned Washington State. Washington State also has a state tax, but in California, we do not have a state tax. This is another benefit as California residents we have. So it, as Michael mentioned, it really depends, when you encounter the specific rules, you need an expert to guide you into the insightful knowledge. Okay, so
Even just a quick pop in, California, we generally, unless you're in a Melrose area or have the supplemental voters taxes, the property tax is just the property tax that pays for sort of everything, county, state. We don't have a division like some of you may own property in Florida. Florida will have a tax that's just the property tax, which is not small, usually 1% or more. And then they have an additional school zoning tax. So they actually fund the schools on its own taxing system. So you essentially have two components of that tax bill, and it's not a small amount.
So there are two scenarios actually definitely
Yes.
what cause the property tax reassessment. The one Michael just mentioned is changing ownership. The other one is actually new construction. For this webinar purpose, I think we'll spend more time in discussing changing ownership. And the next question would be, Michael, what would consider changing ownership? Because if there is changing ownership, we know the property tax will be reassessed. But as we all know about the laws, it's all about exclusions, exceptions. So the next question, I think we are going to deep into this $1 million question: what is considered changing ownership, and how can we structure the transaction to protect our property from reassessment?
And a couple of things here. And great slide here with change of ownership. And I actually left out the other thing that I could do is new construction. So if I have a home and I it's a long time family home, it's a beautiful part of California, and I say, yeah, actually, it can happen, throughout the Saratoga Hills, up towards Atherton. Originally from Southern California, there were a number of people along the California coast that had these things called beach cottages or surfer cottages. That they were these little 2-room. So you have a husband side, wife side, and then you have like a little bathroom and a kitchen in the middle. And they were like, seriously, like 850 square feet, these little things. But they were built in the 50s and 60s on these big lots. Everybody would, say, oh, I'm not going to live in an 850 square foot house. They knock it down, build something new. That will also trigger a reassessment when you change the structure if there's new construction. The rules on that are very complicated. We won't quite go down that road. We're going to focus more, and what estate planners focus on is the change of ownership.
Megan, let's go to the next slide. Okay, Michael, can you
Yes.
give us a brief introduction of changing ownership?
So this is the concept of change of ownership, and I'm going to preview something that Xiaowei, she's already previewed, and to try to help also if those of you joining us on this have looked at the way the materials are on this from the Board of Equalization, their letters to assessors, and their assessors handbooks. How to understand how this works is it is 2 parts. And this is where I see a lot of people get confused, where they will say something like they confuse the analysis of having 1 part when there's actually 2 parts. And it essentially works like this. The first part is the action a change of ownership? Is this, whatever is done, considered a change of ownership? There are a number of situations where the answer to 1 is no, that's not a change of ownership. And so let's say revocable living trust or something, potentially not a change of ownership. There are certain things that's not considered a change of ownership. And then there's other situations where we say this thing is a change of ownership, but then we get to number 2 is, well, okay, there's a change of ownership, but is there an exclusion? So we have to think about those 2 things, because sometimes I see people, which is natural, they'll jump to and say, well, when you do this transaction, you do this particular thing, there's no reassessment of property tax. The conclusion is right, but often people will say, there's no reassessment of property tax because there was no change of ownership. That analysis is actually wrong, and you have to be very careful with this. There was a change of ownership, but that change of ownership was excluded. And you have to draw a distinction from, is it a change of ownership, but it's excluded, versus is there no change of ownership?
Great.
So,
I think the best
yeah.
way for us to understand it probably is to study some examples. So let's go to the next slide and we can take a look at some examples. So in this case, in 1970s, mom bought a house in Palo Alto. And when she bought the house, the base year value is about $500,000. And now the fair market value of the house is $5 million. So Michael, the first question is, if the house was sold and this year, for example, and it's sold for $5 million, is there a change in ownership in here?
100% change in ownership. This is where the county tax assessors, yeah, we 10 times I increased the tax roll on that one. This is the big cheer for the county tax assessor on the classic
Yes.
sale. This is why we make this one example number one. The prototypical party A and party B are different people. Let's just say in this example, Cindy's somebody else, mom and some stranger. This is the prototypical change in ownership. And that would cause a complete change in ownership. And there is no exemption floating around, no exception here. So this would be, the roll would go from $500,000, which is her base year value for that particular year. But once it sells, it is now going to be based on the $5 million.
How about instead of selling it to Cindy, mom, for example, just sold that to daughter? Will that consider a sell too?
And
the
yes,
reassessment will occur?
and this goes right into that analysis that we said that yes, but is there an exclusion? So we'd say the sale from parent to child is a change of ownership, but there may be an exclusion under Prop 19, which we'll see later. So our answer to the first question is yes, change of ownership. At risk of reassessment. And then we have to pivot and say, is there potentially an exclusion?
What if mom gifted the house to daughter free of charge? No, mom
No
didn't
sale,
get
no consideration.
Yeah.
Between each side. Same analysis is change of ownership. That's a change of ownership. Question is there an exclusion? And this is where we get some confusion that's still lingering out there about the old Prop 58. And that was the old system where the parent to child transfers between parent and child for primary residences. The exclusion essentially swallowed the rule, since under the old system, parent could transfer the property to child, and there's no issue about value. There's no residency requirement. You could just do it. And people began to get the off the cuff idea of that, well, there's no change of ownership. This one just doesn't apply. That analysis, when you break it down, is wrong. There is change of ownership, and then you apply an exclusion. Prop 19 changed the way the exclusion works.
The next scenario, actually, we see that more often, more and more often, I would put that way, is mom during lifetime just add daughter's name onto the title of the house. And now mom and daughter hold the title together. Is that considered change in ownership?
And this one again, yes, this is also a change in ownership. So we have this, I might have triggered a change as to 50% of the property. Then the analysis moves to, is there an exclusion? Am I going to try to use the Prop 19 parent to child exclusion because we live together? Maybe am I going to try to use some co-tenants exclusion? Maybe that would work. But we have to be cautious is that I am triggering a change of ownership, and I need to match it. I need to bookend it with the matching exemption.
And the last one would be mom passed away and daughter inherited the house. And is there a change?
And this can occur with estate planning or without estate planning. And this is a passage through someone passing away that person passing away, if the title is changed through probate or through the trust transfer, et cetera, that is a change of ownership. And then you're going to have to look for exclusion. Does the parent-child exclusion exist? Does the co-tenant exclusion exist? What can we do to bookend this relationship? If we could say change of ownership, exception, it drops away. We have change of ownership, no exception, value goes forward, or the reassessment goes forward. We can't block it.
So as we can see from these examples, changing of ownership usually happens either by sale, gifting, or death. So when this happens, usually there is change in ownership, and the question is whether this change of ownership falls into one of the exclusions and will not cause a reassessment. And to study that, I think one law, especially, it's a recent change of property law we really need to understand is Prop 19. So Michael, can you do a brief introduction of Prop 19 before we go to the next slide to compare the current law and the formal law and tell the audience the current exclusions?
So Prop 19, maybe I'll editorialize a little bit. And I joke, I'm a lifelong Californian. My family, at least the Chinese part of my family, have been here since 1840. So we've been here before California was a state. And the only thing I like more than living in California is complaining about California. And this is kind of one of those things. Prop 19 is a massive tax increase, essentially, on California real property owners. And essentially what it was one of those things that was done through the proposition system, and it had a Trojan horse in it, so to speak. And it was basically trotted out as tax equality for the elderly and other adjustments. And people read the header and said, "Oh, tax equality for the elderly. Yeah, I like it." And then they read the first part and said, "Oh, yeah, if you're over 55 or disabled, you can move your property tax, around. So if I have a property and I want to downsize and buy a property of lower value than what I have now because the property I have is too big, and the only thing preventing me from doing that is that my property taxes would go up. This bill would help you. It harmonized that system for older Californians. That header all looked good. The Trojan horse, the sort of soldiers inside, the wooden horse here that came out was the other adjustments were, oh, by the way, we're repealing Prop 58. The parent-child exclusion, we're going to massively change. And so this caused a significant effect for estate planning for Californians, because the old rule, which was very generous, of, well, my primary residence, as long as it goes to the kids in some form, there will be no reassessment there. They don't have to live there. It doesn't matter the value. It's just as long as it goes to them, they'll keep the property tax base. That'll be fine. And I used to have this $1 million wild card that I could apply to my rental property, so I could give my kids the primary residence and these other properties also at a low tax base. It was Prop 58 was very generous. Who could you maybe I shouldn't say blame, but who is held up as the punching bag for this? And actually, if you read the header on it, if anyone's familiar with the actors Beau Bridges and Jeff Bridges and their mom, it was basically to try to punch at them. The mom was they're very famous actors. They're have hundreds of millions of dollars. The mom also owned a lot of land in Malibu, as did they. And basically, when the mom died, the Beau and Jeff Bridges inherited all of this Malibu property, acres and acres of Malibu property, all these shopping centers and everything. And they said, "Oh yeah, it's a Malibu shopping center. Yeah, you pay, it's assessed at $26,000 because you bought it in the 50s or something like that." And this effort was to try to say, no, none of that, that's all going to get reassessed. Well, that's what we got. Shall we introduce us a little bit into the current Prop 19 that is very, very
Yes.
restrictive.
Yeah, so we know the originally the Proposition 19 was brought up to help with the seniors and the victims of a wildfire or natural disasters act. But as Michael mentioned, one thing they did the change, which actually affect a lot of our clients, is the parent-child exclusion. So now we have a more restrictive parent-child exclusion after Proposition 19 passed. Essentially, the effective date, it was passed in 2020, but then the effective date is February 16th, 2021. So after that, if you either gift your real property or after you pass away, your child inherit your property, the property tax, the rules really change. So you really need to understand the new rules. And as Michael mentioned, compared to the old rules, it's a lot more restrictive. And we actually, in here, we provide a chart for our audience to do a side-by-side comparison. And Michael, if you have anything to emphasize, we can,
Yeah,
discuss about that.
friends, memorize this chart. Take a look at this chart and be aware of what has changed. The key changes is that the parent-child exclusion is massively reworked in that, first off, the transferor, I'm the parent, the transferor, this has to be my primary principal residence. Key thing on here is I need to claim my homeowner's exemption on the primary residence. So that $7,000, that little card that says, this is my primary residence, I need to put that on the property that I consider as my primary residence. In addition, I have to arrange my estate planning for this property to go to my child, the transferee, and go to the child, and one of them has to live in this property. So the new rule for Prop 19 is it must be my primary residence and it must be the child's primary residence. Transferor and big star or big circle around it, and transferee. That didn't used to be the rule. It used to be just the transferor. We only looked at the transferor. Now we look at the transferor and the transferee. We'll see in a moment. If the transferee moves and doesn't claim that property as the primary residence, then you lose you lose this low assessment, and it goes back up to what it gets reassessed. Even though that time you didn't actually do a deed or anything, the person just moved away. The child said, "Oh, I was living in mom and dad's house after they passed away, but my job took me to Southern California. I'm going to move there." Well, then that Northern California property gets reassessed. So that's a big change. Critical, and this is goes back to sort of the beginning of our lecture of how complicated this is, and what a little bit of homework for everybody to do is take a look at, if you have multiple pieces of real estate, which property has the homeowner's exemption attached to it, especially if you move. Is it on the old house or the new house? Did I bring that over, or did I not bother to bring that over? If you didn't bother to bring it over, that can be a problem with this. You can have this latent problem sitting there. The same way, if you've never claimed the homeowner's exemption, you never sent the card back, that can cause a problem. They luckily fixed this. I had a case in 2022 and early 2023 where it was fighting a lot with the assessor's office. It was a retired person had dementia, moved into assisted living because he couldn't live on his own. Daughter started to live in the house. He died. Daughter inherited the house. They claimed the Prop 19. They said transfer or transferee. County said, "Oh, no, not Dad's house. Dad died in the assisted living facility. That was his house. He wasn't the transferor. Reassess." Actually, Assembly or the California bill SB 530 fixed this in 2023, but we have to be really careful because this transferor transferee is a big problem. In addition to this, the $1 million value is now in play. We now in Prop 58 never had a dollar figure value, but we have one here now. Is that the property? If, and we'll have an example slide on this. If the difference from the parents' base assessment, the years that they've been paying property taxes, that assessment, and then the current fair market value is more than $1 million, that difference comes back around and is added to the assessment for me. So if the property has gained a lot of value, I'm going to see some increase in my property tax. So this is a big change. And then the other key thing that is a big change, California Prop 58 was very generous on this, is there used to be basically this wild card, this $1 million of, they call it factored base year value, that on my other properties, if I had a La Jolla cabin or La Jolla beach cottage, or I had the Tahoe cabin, I said, well, actually that one's assessed at 800,000. Under the old law, I could exempt my primary residence. Boom, that's out. And then I could take this $1 million wild card and say, oh, I'm going to apply it to the La Jolla beach cottage, and my son and daughter will get the family house, and they'll get the La Jolla beach cottage, and they'll all keep the same property tax assessment. That one, Prop 19, just brings the hammer down on that and just says, no rental properties, only primary residence. If you own, more than one property, all of those other ones are going to get reassessed, unless there's another exclusion, which we'll see later. But, parent-child, it's not going to protect those other ones. That party is over.
So that really affects clients who have investment properties, because it looks like, at least, from this, the client can not really exclude any reassessment of for investment properties. The only exception would be a primary residence.
Under this exclusion. So this is something that one now needs to think about in their financial planning, real estate planning, and their estate planning of, oh, my plan of the primary residence and the beach cottage kind of being the plan, and that my kids will just rent out the beach cottage periodically and earn some income from it. And the property tax assessment is low. We're going to use that beach cottage as income. Well, does that still make sense if it's going to be reassessed? And then, maybe not. Maybe we have to think through what we're going to do with that. The same way is, do we want to adjust our estate planning to maybe seek another exemption if possible? Maybe that's in play.
Let's take a look at a couple of examples. So for the example, we have the same scenario. Again, mom bought this house and the base value is $500,000 and the fair market value now is $5 million. And so the first one is if mom gifted the house before she passed away, and mom gave the house in 2020 before the passing of Prop 19. Michael, what would that cause?
Well, the dates matter. This one, if she gifted this, and we did a lot of planning of this before 2021, in this scenario, mom would have been covered under the law of Prop 58. So daughter would have the house at the low assessment, because under the old Prop 58, you could gift parent to child and the value didn't matter. The residency didn't matter. If she then does this in 2025, there is a change. Both situations have a change of ownership, but in 2020, you had a total exclusion under Prop 58. In 2025, same thing, change of ownership, but you do not have a full exclusion under Prop 19. You only save $1 million. So you take 5 million, minus 500, so we're at 4.5 minus $1 million, we're at 3.5. You add in the 5, you're assessed at 4.
Mm-hmm.
So enjoy your 40,000 plus property taxes per year. This is critical. This is critical because I have clients with special needs children. They say there is no possible way my child, $40,000 is almost not when I was young, that was a good salary. Your entire job is property tax. Even you have a good salary, you're 120 or something like that. A third of your income, a third of your gross income, property tax, no problem.
Yes, I think for investment properties, it's even more problematic because if you have very high property tax, you do not have enough profit to cover all the expenses.
Critical in two areas. One is, again, thinking about one's real estate portfolio. If my real estate portfolio is mainly residential, residential generally does not use a triple net lease. That's going to bite me pretty hard. If these get reassessed, I'm going to have to figure out what to do because it changes my net sheet. If I have properties that are commercial, maybe I need to start getting the tenant used to a triple net lease and then prepare for what I'm going to do at that flip point. This is another problem, is that we've had with our commercial clients. Something happens, we have the triple net lease, we say, tenant, that's your problem. Well, it's sort of that, you owe $1 million, it's your problem. You owe $100 million, it's the bank's problem. Anyone who deals with the landlord tenant, it's a constant push and pull. At first I seem like, sure, I'm going to stick the tenant with this, and then the tenant's really mad, and the tenant says, fine, I have a 5-year option. Nuts to that, not going to do it. It's too expensive now. Now I have a business decision, because do I rather want them to do the option? I need to entice them to exercise the option, but if they know the property taxes are so high, and I'm gonna push it over to them, maybe they won't exercise the renewal. There's a lot in play here.
Okay. And if mom has, so, let's change the scenario. If mom has 2 children, son and daughter, and, in mom's estate plan, mom said both son and daughter get this house. So if just the one child, for example, daughter lives in the house, but son could not live in the house, or son has his own house, will that still be qualified to avoid
For the residency
reassessment
rules,
under Prop 19?
yes. So this was clarified by the Board of Equalization. If you have multiple children, as long as one of them lives in there, that's enough. If you have 3 children, they don't all have to live in there together or something like that. They clarified only one needs to be in there, and only one needs to be in there at a time. So if you have daughter in there and she's living there, and then son says, I'm coming back from college, or I'm going to move back to California, you're going to go over to Florida. You can swap it, as long as you have some child living in the family house and claiming the exemption, then you'll be okay.
But assuming, for example, son is not in the house and the daughter now has to leave too because, daughter accepted a new job, for some other reasons. So nobody, I mean, no child lives in that house now. What would happen?
Then we have the bad situation. Then when no
Is it
child,
as soon as nobody lives there, the property tax will be immediately reassessed?
essentially, yes. And so essentially, the once the person leaves, they say that's the transfer point. There's no longer a valid claim of exemption, and we reassess. It's no longer the family home to take care of the family. This is very different from the way we used to do it, where it didn't matter, what the transferee was doing. Now it matters not only the transferee at the time that they take ownership of the house and they're the resident of the house, but if I leave, there's a problem. So this is, again, thinking through, this is a different world in terms of property tax. And then this is just a calculation of what we
Yes, so
expect.
now, we know the house will be reassessed. And can you explain a little bit how this works if the house is reassessed?
And this is just this is that mathematical part, because there is a limitation, a dollar figure now. So that now Prop 19, this exclusion, we have the change of ownership. We say, okay, change of ownership, there's going to be a reassessment. Prop 19 says, don't worry so much. It's parent to child. Say, okay, how much do I need to worry? Prop 19 says you need to worry this much. Actually, when you look at this, you say, I need to worry a lot. Actually, I need to worry a lot because it is essentially the exemption is capped at a dollar figure of $1 million. So, like in our example, we have this, 500,000 plus the million. We've got 1.5 of exemption. 5 is what was already assessed plus the exemption, but the fair market value was 5 million. You subtract the 2, the the new base year value for the daughter going forward is 4 million. So if the property sold for 1.5 million, let's say it was not such a valuable property, then she'd be okay. Then she wouldn't have this problem. If the fair market value was 1.5, then she would have effectively used the million and she'd be all right.
I think that this feels like this is more designed for, a house worth about 1.5 or, less than $2 million. But if you have a very valuable principal residence, this $1 million is really not so much, as we can see from this example.
And this was I would say um uh flagrant, or was advertised in Prop 19. It actually said, like, if you read the header, it's actually hilarious. That said, Prop 19 is used to combat pernicious property accumulator. I think they call it property accumulators and things like that. And they wealthy, and they call it wealthy coastal Californians and things like that. We're not on the coast. I don't see any ocean near here, but they basically were punching at us. And it is trying to aim at a different kind of property tax base. Is trying to aim at a little bit of a lower value real estate holding California.
Mhm. Okay, so after parent-child exclusion, I think another topic we really want to, bring up. I know there are many, many, many complicated exclusions, but I think one important one, as estate planning attorney, we really
And
want to point out is the
and
interspousal
and
transfer.
actually, could I just go back
Oh,
to
sure.
2 slides back, one more? This the number 8 case study, mom gifting the house to daughter in 2020, or just the idea of gifting. I just want to put an asterisk or a star by this. Do remember, and this is where this gets complicated, if we couldn't make it more complicated than it already is, but do remember, in this scenario with mom gifting the house to daughter, she did in 2020, she did a great job with saving the property tax. So she did great with saving the property tax. She avoided the reassessment because she had a change of ownership, yes, but she had a total exclusion under Prop 58 for local property tax reassessment. But if when I teach in the law school class, I'd say, well, what was mom's what's the concern for daughter? I open it up to the class. What's the answer? Someone would raise their hand and say, Professor Lee, Section 1014 of the IRC, carryover basis. Daughter now has the $4.5 million carryover, or the her basis is $500,000. So she has built-in capital gain of $4.5 million. So if daughter sells in 2021, daughter absorbs the full punch of of capital gains taxes on the 4.5 million. So this is, again, balancing these things. And back in that era, we had to balance this because we say, well, you did a great transaction under Prop 13, Prop 58 property tax rules. You kept the property tax low for the daughter for a long time. But the key question is, a daughter's going to live there her whole life, right? I say, nah, she'll live there 2 or 3 years and then she's going to flip it. This may not necessarily be a great transaction, because if daughter inherited the property, if mother passed away and daughter inherited the property and then quickly sold it, she would pay no capital gains tax, and the property tax reassessment maybe for a very short time, less than a year or two. If I was going to inherit, fix up the property, and then sell it, I would probably, in that scenario, prefer the step up in basis rather than the savings on the property tax increase. But again, at 4.5 million, $40,000 a year, it's going to depend how long I'm going to hold it. So there's two tax systems in play.
Yes, I'd also like to add, other than the capital gains tax you just mentioned, you also need to consider, if mom is a high net worth person, you also need to consider the gift tax and the estate tax.
Yeah.
Because when you gift the house or you add your daughter's name onto the house, you may not realize it, but it's a gifting event. And if it's a gifting event, other than the annual gifting exemption amount, it will also also use part of your lifetime exemption, estate and gift tax exemption. So $5 million may be used as part of the exemption, and you would lose $5 million when you pass
2011 would have
away.
used all of the exemption.
Yeah.
Back from 2011 until 2017, it would have used almost all of the exemption. So a lot in play here. That one would have to look specifically. So great. Let's
Yes, and
proceed on.
Yes, let's just talk a little bit about the interspousal transfer, because we know, we also see a lot, this is in real life, between spouses, sometimes we change titles. So, if I own a real property, later on I get married, I want to add my spouse onto the property. Or, if I'm divorced, it's husband and wife, they own a property together. And, when after the divorce decree, maybe this property is just mine, or my ex-husband's, well, that cause a reassessment of the real property.
And this is a classic example of change of ownership. Yes, went between different persons, but very, very broad exclusion. So transfers between spouses, so in and out of trust for benefits of spouses, changing from husband to wife, wife to husband, husband to husband, wife to wife, all of that is okay. So adding a spouse on, removing a spouse, transfers upon the death of a spouse. My spouse passed away, it now goes to me, or transfers because there's a divorce. That will not that will be excluded. So yeah, change of ownership, yes, but then exclusion will take care of it. And this is the classic thing, like how do you claim the exclusion? These are claimed on the deed. These it's typed in sort of bold lettering on the deed, and so that when you record it, you say it goes from Mike Lee to Susan Lee. It was Mike Lee, single man to Mike to Susan Lee, a married woman. We'll put it, say, well, that Mike Lee, an unmarried man, that was at the time, that was before he was married, and then he got married, and then now it's going over to his wife. That actually is okay, as long as we're married at the time. Maybe because my wife has a good job, like W-2, and she needs to borrow against the property. So there are family law issues. Maybe I don't want to take my separate property house and then title it as my wife's separate property, but maybe we're really close and she could get a good loan and I want to do that. There's some thoughts in there, but this interspousal, we generally are going to be okay if we're between spouses or former spouses, or spouse passed away. Those ones, there's a broad exemption here.
Okay.
Let's go on to the ones that are really complicated.
Yeah, so after, we did this thorough analysis of the Prop 19, Prop 13. I think what we really want to know is, in this post Prop 19 era, is there any way we can avoid reassessment, or we can structure the transaction to avoid or delay probably reassessment? Do you have any suggestions for our audience? I know it's very complicated, but can you just provide some broad idea? And then, if our audience, they have some special requests, they can just send us a message and we can discuss in private.
And there are a few ways to do this to try to avoid or delay reassessment. And usually the options are using either legal entities or joint tenancies, or converting the tenants in common to a joint tenancy, or doing things in using the other exclusions. And a lot of people, you'll probably say, oh, I really want to hear all about the exclusions. And we'll tell you a little bit about them. But the reason why I'm actually being a little bit cautious in talking about the exclusions is because they are very, very, very complicated. And it matters not just what your deed says now, but it matters how I obtained ownership, so where this deed was coming from, and then where it's going. So a lot of people will say, we'll talk about one like this. So an LLC, so business entities, change of ownership is considered change of control of the legal entity. So if I have an LLC and half is owned by me and half is owned by my brother, 50-50, and then we have it designed upon our passing that 50% goes to my son and 50% goes to his daughter, and this 50-50 line down the middle never changes, that would not trigger a reassessment. But what was the deed before? I said, oh, Mike, but yeah, the LLC, my brother and I, we didn't buy it in the LLC. We bought it as Mike and brother, and then we put it in the LLC, and then we did this. Doesn't work. That doesn't work anymore. The LLC was not the original owner. So then there's this whole original transferor component of who's the transferor. So you have to be quite careful in that scenario. Is that when I laid it out at first, it sounded great. It sounded great, this LLC. It sounded like the client had done it the right way. But when you look back at the deed before the current one, oh, you realize, oh, wait, you blew it. No, that's not the way that works. You've got the order wrong. We're going to aggregate the transfers between you two. And as soon as you have the 50% to the first person, that's going to be a reassessment on half. And then 50% to the other person, that's transfer on half. That's a problem. So we have to be cautious with this information on the legal entities. They can work very well. This was pioneered by Michael Dell. So if anybody wants to know why Michael Dell, his wife, and for some reason his wife's brother bought the Santa Monica Fairmont together, because they needed to keep the fractions the same as the seller of the Santa Monica Fairmont. Famous case called the Ocean Avenue case, where we get a lot of these rules as to the legal entity change. You can also, in some situations, have an avoidant or avoid the reassessment or delay the reassessment by using joint tenancies and the co-tenancy exclusion at death. But you have to be very, very careful with this, because it matters how did the joint tenancy come about. And the rule under the co-tenancy exclusion is very strict in that there can only be two co-tenants, A and B. I said, well, it was mom, and then it was my brother, and it was me, all three of us. It's not maybe necessarily going to work under that strict reading of the co-tenancy section. Maybe we need to see another section. So this is something that is so fact specific. It really warrants looking at the actual sequence of events, because just like that one with the LLC, if I heard the initial story, I'd say, great, you're good. 50-50, do your estate plans 50-50, send 50 down that way, 50 down that way, you're not going to be reassessed. As soon as I hear about then the deed before that, I realize, oh, ignore all of that. I'm totally wrong. That's exactly not what's going to happen. So that's why there's a little bit of reticence to start outlining, the legal entity things, and why we spend more time on parent-child. Parent-child is more common, a little bit easier to get one's arms around, and those rules on their face and the facts on the face lead to more predictable results. The rules for legal entities require, really knowing the deed before, the deed now, and then the deed that's going to happen later. We have to know, past, present, and future to give a better answer. So we have to be, it leads to too many variables. So that's,
And also, I think it's important to consider the issues in general. I mean, you have to deal with property tax, of course, you have to consider that. But you also have, as Michael just mentioned, you also need to think about the startup basis, the capital gains tax, the gift, the inheritance tax, because, I just want to add, like, joint tenancy, Michael just mentioned that, maybe there is a way you can avoid reassessment, but from a estate planning attorney's point of view, sometimes it can be a real disaster
from an
for
asset protection,
inheritance.
and this is again the chart from an estate planning attorneys. They say, you're insane, Mike. What if the child dies before the parent? And the child has kids, so the parent has grandkids. You just X'd out all of his kids from, it's an estate planning, just boneheaded mistake to do. So it's like, and you're like, right up.
Yeah. And
And
also, if somebody is incapacitated, it's also a big problem.
yeah, and just like that, so like the estate planning attorneys were like, what do the tax advice was right, but when you overlay it with estate planning, it's wrong. Same way I pivot, I say asset protection wise, I go the same way. I'm like, why would you add a high risk person as a joint tenant onto a property? You're just serving up the money to the creditors. And all they need to do is record an abstract of judgment when there's the lawsuit. They just record the thing and they've got a lien on the property. Like, why would you do that? So that is also in play. These decisions require, not just the tax consideration of the past, present, and future, but you also have to then look at this in another angle. Am I happy with this from an estate planning point of view? Am I happy with this from an asset protection point of view? And did I not do something kind of silly where I lowered this tax and then I ended up raising another tax? So that is interwoven in a way that is, you're best advised by giving the specifics and then getting a specific answer, instead of kind of a generic answer where, and this is where where actually the knowledge can kind of hurt you. You end up with like 80% of the story, but that critical part didn't get. That can be very helpful.
Great. With that, I think that concludes today's webinar. And I also like to invite the audience to join our April webinar. And in April, it's tax time. So we're going to do a tax webinars. The topic is avoiding tax scammers and prepare for IRS communications during tax season. And it will be held on April 3rd. I believe it's a Thursday, at noon, the same time. So if you're interested in that, feel free to scan the QR code and register for the webinar. Last but not least, let's spend about 3 to 5 minutes to answer 2 questions we have. So if you are engaged, you need to go. Feel free to leave the webinar. But if you are curious, we're going to answer 2 questions we received during the webinar. One question is, does adding a child to the grant deed ownership trigger a reassessment of property value for property tax purposes?
This is a complicated question. Generally, in adding the child as a tenant in common, it will add them, or it will cause a reassessment of the fraction that was transferred. So if I add my child on as 50% tenant in common, that will be a change of ownership to that 50%. There would be a potential reassessment on the 50%. And then there would be, does an exclusion apply? So does Prop 19 apply because my son's going to come live with me, or is there another exclusion? The other consideration, though, is that there are situations where I'm not adding my child as a tenant in common. I'm adding my child on as a joint tenant. There is law and supports that if I add my child on as a joint tenant, that's not a change of ownership as long as I stay on. But be careful with this. This is one of those, I've had a few arguments with the county on this one, is not every county has reacted that way. Even though there is, under the assessor's handbook, there are citations in the assessor's handbook that says that the joint tenant addition, as long as the first joint tenant stays on, doesn't trigger a reassessment. I have had some counties push back on that and say, no, the tenants in common rules should apply. So again, be careful, like how specific this is, kind of giving a joint answer. There can be some really local, literally down to the assessor's office, how they treat this, even though the handbook gives kind of an answer on it.
Okay, so the next question is, since a deed for real property, real property is public record, is it easy for honest people to forge my signatures and transfer my deed to them without my knowledge at all?
It is possible. There has been there's a service that's advertising now that advertises like a property title monitoring service to give you some security on this. Essentially, the way the title recording system works is, it's a little bit odd, but we use deeds, and essentially there'd be the deed would be drafted up. There would have to be a signature of the owner, and it has to be notarized. So there's a potential safeguard of the notary, but finding a notary is not that hard, or forging the stamp may not be that hard. And then it has to be recorded with the county recorder. So in theory, there is some security vulnerability on this. So there could be potentially a risk here. The challenge then, the question then is, how to prevent this, and what the fraudster could do is putting them, once let's say they're named as the owner, just having that, they really can't do too much unless they try to sell or borrow against the property. And that, if they're trying to borrow against it, usually lenders will kind of figure out, or there will be some weirdness of how they got title to the property for the lender. Sell the same way, because they're going to need title and escrow, and this may come up. So it is what I think stops a lot of this kind of crime is it is hard to extract the money from this. What to do to protect oneself? Of course, monitor your mail. If you get anything in the mail that looks odd, like, why am I getting a mortgage statement from XYZ bank? I don't have a mortgage with that. Well, we better check. There could be a problem. There's a judicial way how to knock out that deed if it's a false deed. It's called quieting title. I mean, you don't want to go down that way, but there's a procedure to do it. But you can do that. The other thing what one could periodically do is ask a friend from a title, every couple of years, ask and one could even pay for it, request a preliminary title report from a title company, and just say, what does everything look like, and take a look and say, yeah, same deed from 1987 as was before, nothing else on there, good. That would be a way to protect oneself, is to check the title report. Generally, this is done via title companies, and there's a fee for that. There are these other services where you can pay annually, but I'm a little dubious as to the value of that. That's a business decision for you all to think about. So hopefully that helps.
Great. Thank you all for joining us today. I hope everyone have a good day today, and we'll see you next time.
Take care all. Bye-bye.
Bye.